All please rise.
Thank you for standing. Please be seated. Good morning. We are convened in the Iowa District Court for Sac County. This is in the matter of State of Iowa plaintiff versus Lenett Marie Green, defendant, case FECR 012607. Today is the date set for further hearing, which the court understands is a hearing to consider a plea agreement of the parties. My name is Jim McGlynn. I'm a district court judge assigned to hear this case. We are reporting the proceedings, as you can see. I'd like to have everyone else identified for the record. We'll start with the county attorney and just go down the council table.
Ben Smith, county attorney for Sac County.
Bob Peterson, attorney for Lenett Green.
Lenett Green.
Okay. And thank you, folks. And am I correct that the parties have reached a plea agreement that is to be considered today?
That is correct, Your Honor.
And do you want to summarize what the state's understanding of that plea agreement is?
I will, Your Honor. Thank you. Your Honor, defendant Lenett Green was charged August 27, 2014 with count 1, manufacture, deliver, or possess with intent to manufacture methamphetamine, which is a Class B felony. The state has offered defendant an amended count 1 to a Class C felony in violation of Iowa Code 124.401, sub 1, sub C. And again, that's a Class C felony. If defendant pleads guilty to that amended charge, the state will recommend to the court that defendant receive a suspended sentence. The defendant be sentenced to the Department of Corrections, because that's the only place that she can go if it is a Class C, but that court suspend the sentence. And also, in addition to the suspended sentence, the state would also recommend that defendant's fines be suspended as well. The defendant going to have to pay court costs and cost to reimburse her court-appointed attorney, Bob Peterson. That's the substance of the agreement. If I missed anything, I'm sure Bob will fill in.
Okay. And Mr. Peterson?
Thank you, Your Honor. That is our understanding of the plea offer also.
Okay. And I want to be sure that so this would be a plea to the Class C felony of less than 5 grams of methamphetamine.
I believe so, Your Honor, but I'm looking as well.
That's our understanding, Your Honor.
With a minimum fine of $1,000, maximum fine of $50,000.
That's
Law enforcement initiative surcharge, dare surcharge, and the license revocation. And if prison is ordered, there would be minimum sentence of a third. Would have to be served.
yeah, sure.
You understand? All right. Well, Ms. Green, the attorneys tell me that this is what has been agreed to. Is this what you are willing to do?
Yes.
Okay. Before I can even let you do that, I need to go over quite a few things with you because I need to make sure that you understand what you are doing. I want to make sure that you understand the consequences of what you are doing. I want to be sure that you understand that you have quite a few rights which protect you here in the courtroom, which you, of course, give up when you plead guilty. And I want to make sure that you really did do something illegal to bring you here in the first place. As we go along, feel free to consult with your lawyer. He's here to help you. If you need to take a break at any time to visit with him, we'll do that. If you don't understand what I'm saying, if you have any questions or need me to repeat something, let me know that. I need to have you answer out loud. My co-reporter and I each need to hear you, and the acoustics here are not always the best. So I need to have you speak up, and if you mean yes, say yes. If you mean no, say no. You can't just nod or shake your head because my co-reporter can't take gestures, only words. All right. Again, if you go along, feel free to consult with your attorney. How old are you now, ma'am?
29.
And what's the extent of your education?
I got my GED, and I went to college in Denison. That's
Okay.
right.
And can you read and understand the English language?
Yes, I can.
Okay. Are you currently under the care of a physician or a psychiatrist or psychologist for
No.
anything at all?
No.
As you sit here today, are you under the influence of any medication or alcohol?
No, I'm not.
In the last 6 months, have you been hospitalized for any matter?
No. Oh, 6 months, yes.
In the last 6 months, you have?
Last June, I was in the hospital in Worthington for my kidney infection.
Okay. And June would be a little more than 6 months, so are there any lingering issues with that
No.
that would not in any way affect your ability to know what's going on here today? Have you had enough time to visit with your attorney?
Yes.
Are you satisfied with Mr. Peterson's services?
Yes, I am.
Now, I need to explain to you that you have quite a few rights which protect you here in the courtroom. Those rights are guaranteed to you by the Constitution of the United States and by the state constitution. That's a lot to understand in a short while, but it can be summarized by saying you have the right to have an attorney and you have the right to remain silent. Maybe when you got arrested, probably when you got arrested, a police officer advised you of what are called the Miranda Rights, that you have, or perhaps you've seen or heard those stated before on a television show or a movie. But what the summary is that you have the right to have an attorney. If you cannot afford an attorney, I want to be appointed for you at public expense. You have the right to remain silent. Anything you say can and will be used against you in a court of law. That's the short version of all that. Have you heard that before?
Yes, I've heard it.
All right. So the right to have an attorney is pretty straightforward. That's why Mr. Peterson's been appointed to represent you, and he'd be, and I'll go over this in more detail in a moment, but he would help you throughout the proceedings. And that's why I told you if you needed to take a break to visit with him, you would do that. The right to remain silent, though, is more involved. What it basically means is that you don't have to plead guilty if you don't want to. You don't have to say anything at all about the facts of this case unless you choose to do so. And if you'd rather, you could have a trial. At that trial, you'd be presumed to be innocent until the state convinced the jury, unanimously convinced the jury, beyond a reasonable doubt, that you are guilty. And so the way that would proceed is that a panel of citizens from this county would be called in. Your lawyer would be there with you every step of the way and would help in the selection of the jury. 12 people would sit as the jury. And as I said, they would have to be convinced unanimously. It's not 11 to 1 or 10 to 2. It has to be 12 of the citizens of this county would be convinced beyond a reasonable doubt of your guilt. So your attorney would assist you by trying to find 12 people who could be fair and impartial in that process. He would help you by making statements and arguments to the jury. He would help you by making statements and arguments to the court on the legal issues. The state would have to present the evidence. You are presumed to be innocent, so the burden of proof is on the state. And the state would have to bring the witnesses into court to testify under oath up there on the witness stand. And each of those witnesses would have to testify in front of you. Your lawyer would help you further by asking questions of each one of those witnesses to make sure that each witness was really telling the truth and not mistaken. Your lawyer would help you in presenting your case. If you wanted to testify, he would help you present your testimony to the jury. But you have the right to remain silent. So you would not be required to testify, and no one would hold it against you if you chose to remain silent. But if you chose to testify, that is your right, and your attorney would help you with that. If there was other evidence that you wanted to present, other people, or physical evidence of any kind, your attorney would help you by obtaining subpoenas to get that evidence into court. And as I said, you would make arguments to the jury at the end, help the court with developing jury instructions. After listening to everything, the jury would either be convinced beyond a reasonable doubt of your guilt or not. If they were unanimously convinced of your guilt, then you would be convicted, found guilty. But if they were not, because you were presumed to be innocent, that presumption remains and you would be found not guilty. Now, it's a lot to understand, but the point of it all is that you have the right to have an attorney and you have the right to remain silent. You continue to have that right to have an attorney, but you basically give up that right to remain silent, because if you plead guilty, that means there's not going to be a trial, there's not going to be a jury coming in, there's not going to be a witness, any witnesses coming in. This is it. And the way the case gets proved is you have to give up your right to remain silent and tell me what it was that you did to bring you into the courtroom. Understand that?
Yes.
Is that how you wish to proceed today?
Yes.
Now, you when the state filed its charge, it filed what's called a trial information, and I've printed out a copy of this. Did you get a copy of this charge?
Yes.
Okay. And at the same time, the county attorney attached what's called minutes of testimony. That identifies the name of every witness that the state would call and provides a summary of what each one of those witnesses would say. Do you remember getting that?
Yes.
Okay. And did you read the trial information and the minutes of testimony?
Yes, I did.
Did you review those with your attorney?
Yes.
Okay. Can the court rely upon the minutes of testimony, that summary of what all witnesses would say if this went to trial? May I rely upon those summaries in deciding whether you actually did commit this offense that you pleaded guilty to?
Yeah.
Now, the plea agreement that I understand is what you're charged with right now is a Class B felony. And the state has agreed to reduce that to a Class C felony, as originally charged. Class B felony is punishable by a prison term of up to 25 years, with a maximum fine of $100,000, minimum fine of $5,000. The state has agreed to amend in exchange for your plea to a Class C felony. It's still a felony, punishable by up to 10 years in prison, maximum fine of $50,000, minimum fine of $1,000. And the state has also agreed to recommend that the fine and prison sentence be suspended. Is that your understanding of the plea agreement?
Yes.
Has anyone made any other promises or said or done anything else to get you to plead guilty that I didn't hear about here in the courtroom today?
No.
And you understand that the ultimate decision is going to be the court. It may be a different judge than me that makes the ultimate sentencing decision, but it's not your attorney, it's not what the county attorney or even you say, it's ultimately what the sentencing judge says. Understand that?
Yes, I understand.
So that means by your plea, you could be sentenced to a term not to exceed 10 years. You could be ordered to pay a fine of up to $50,000 plus surcharges. Do you understand that?
Yes.
Okay. Now there are some other collateral matters that happen when you plead guilty to an offense like this. With a felony, you're going to have to provide a DNA sample. Do you understand that?
Yes.
Because of this, this is a drug offense, you will lose your right to own and operate a motor vehicle for 180 days. Do you understand that?
Yes.
Even if the fine is suspended, there are still surcharges, a $10 DARE surcharge which cannot be suspended, a $125 law enforcement initiative surcharge. Those will still be imposed. Do you understand that?
Yes.
There will be court costs to pay, and those would include the cost of your court-appointed attorney. Do you understand that?
Yes.
Are you a native-born citizen?
Yes.
And the reason I ask that, one of the collateral consequences for someone who's here illegally and convicted of a crime like this is that they may be deported. And so that's not a matter that you need to be worried about, but it's something I need to inquire. So do you understand the consequences that could occur?
Yes, I do.
The recommendation would be that you be placed on probation, and that term of probation could extend for up to 5 years. Understand that?
Yes.
Are you currently under probation or parole or anything?
No.
Do you have any other charges pending anywhere else against you this time?
Yes.
And what are those?
Paraphernalia in I County.
In what?
Paraphernalia charge in I County.
In Ida County? And that is not part of this plea agreement, am I correct on that?
Correct.
So, and that'd be a simple misdemeanor in that county? Ida
Yes.
County. All right. Anything else?
No.
Have you discussed the possibility of any defense of any kind? Any legal argument that you could make? Any motion that you could file regarding the admissibility of evidence? Any matter whatsoever that you might be able to assert to avoid the consequences of these charges? Have you discussed any of the options that you might possibly have with your attorney?
Yes, we discussed it.
Okay. And is there anything that you think would be likely to prevail in your favor?
No.
And Ms. Peterson, is there, other than general denial, is there any defense that you know of, anything that you are aware of in this case?
No, Your Honor.
Indicated before what the consequences were, but let me just review them with you. Consequences which could be ordered, that you could be ordered to serve a term not to exceed 10 years, with provision that you serve 1/3 of that before being eligible for parole. That you be ordered to pay a fine of up to $50,000 plus 35% surcharges added to every fine that's imposed. You be ordered to pay that. We mentioned the loss of license, the DARE surcharge, the law enforcement initiative surcharge of $125. The attorney fees and the court costs. Those are the maximum consequences you could be looking at. You understand that?
Yes, I do.
Do you have any questions at this point?
No.
Do you still wish to plead guilty?
Yes.
And in order to find you guilty beyond a reasonable doubt, the state would have to provide evidence to the jury that on or about April 2nd, 2014, here in Sac County, Iowa, you unlawfully and willfully manufactured or delivered or possessed with the intent to manufacture or deliver a controlled substance, specifically less than 5 grams of a mixture or substance containing methamphetamine. Do you understand what you were charged with there?
Yes.
Okay. You understand that what the state would have to prove?
Yes.
So I need to have you tell me what it was that you did to bring you into the courtroom on this charge.
On April 2nd, I helped assist in the delivery of controlled substance.
And was that controlled substance methamphetamine?
Yes, it was.
And less than 5 grams, is that correct?
Yes, more.
And that happened here in Sac County?
What?
That happened here in Sac County?
Yes, it did.
Okay. As far as the state's concerned, is there any reason that you know why I should not accept the defendant's plea?
No, Your Honor.
And Mr. Peterson, any reason that you know of I should not accept the defendant's plea, or anything that I've admitted that could affect the validity of this plea?
No believe so, Your Honor.
Okay. Well, then the court finds, Ms. Green, that you are voluntarily entering your plea of guilty to the Class C felony charge of manufacture, delivery, or possession with intent to manufacture or deliver less than 5 grams of methamphetamine. I find that you fully understand your rights, that you fully understand the consequences of your plea, and that a factual basis exists for your plea, because I'm considering not only your own admissions, but also the summary of the witness's testimony is set forth by the minutes of testimony. So I will accept your guilty plea. I will schedule the sentencing. I don't have my calendar in front of me, but it'll be about 6 weeks in order to set forth a time and date. I will order a pre-sentence investigation to be conducted, and that takes usually about that long to complete. The terms of release will remain the same. Is there anything else that I need to address for the, and I'll get to the motion and rest of judgment, but anything else then for the state that needs to be addressed?
No, Your Honor.
Or Mr. Peterson, anything else?
No, Your Honor.
Okay. Now, you have pled guilty, but but you still have some rights. And if for any reason you decide that you wish to attack this guilty plea, try to undo this guilty plea for whatever reason, what you must do is file what is called a motion in arrest of judgment. That's an odd-sounding term. What arrest of judgment means is to stop the sentencing, to stop the judgment from occurring. And you can talk with your attorney more about this, but that's the plea that you have to file. The important thing is to know that there's a time requirement. If you want to file a motion in arrest of judgment, you have to do it timely, at least 45 days from today, but in any event, at least 5 days before the date set for sentencing. If you let those days go by, if you do not timely file the motion in arrest of judgment, you forever lose the right to attack or try to undo this guilty plea. Do you understand that?
Yes.
Okay. And again, visit with your attorney if you have any questions. Anything else I need to address for the state?
No, Your Honor.
Mr. Peterson, anything else for the defendant?
No, Your Honor.
Okay. Again, the order will set forth the time and date of the sentencing. And we'll stand adjourned.
Your Honor.